Thank you all for turning up for this Sunday short on law on morality. I'm delighted to see so many of you here. I thought with the title Law and Morality we might be struggling, because the moment you put the word law in the title, you're guaranteed to ensure that any non-lawyer doesn't want to attend. And of course, the moment you put morality into the title, you can be absolutely certain that no lawyer is going to. So, Luke Gitos is I should say there are some honourable exceptions to that characterisation of the legal profession, and you've got two of them right at the front of this room, obviously fine, upstanding, highly moral people. Luke is also going to demonstrate that law and morality is very interesting, particularly to non-lawyers. Luke Gitos, I'm sure many of you know him, having read his articles on Spike about law and politics. Luke is the legal editor of Spike. Luke also organises and chairs the London Legal Salon, which tends to meet in London to discuss legal and political issues. And I understand that in his spare time, Luke also writes for Russia Today. So he's clearly, that's in addition to the day job, whereby Luke is a solicitor practicing criminal law. So we're delighted that Luke has found the time to come and talk to us this afternoon. Luke Gitos.
Okay, so I haven't got long, so I'm not going to make any jokes. Sorry about that. You just have to trust me that I'm hilarious outside this room. The key distinction that we need to get our heads around when thinking about this question is between legal positivism and natural law theory. Now, when I did this, I actually rehearsed this talk at the London Legal Salon last week. And when I did it then, I started by going through natural law theory, the history of natural law theory of Aristotle and Thomas Aquinas. But because John Haldane stole my ideas today, we've already had quite a good introduction to natural law theory. But the key distinction is that at the beginning of the 20th century, a chap called HLA Hart, a Cambridge legal philosopher, publishes a book called The Concept of Law. And it's that book that is now commonly thought to have founded what's known as the legal positivist theory. And it becomes known as the opposition, or the attempt to demolish what had been a hegemonic theory found in natural law theory up until that point. So broadly, the distinction is that legal positivists deny that there is a necessary connection between law and morality, whereas natural law theory broadly holds that there is a necessary connection between law and morality. And I hope that by talking through both those theories, you'll get a clear idea as to what I mean by a necessary connection. So rather than talk about the history of natural law theory, I wanted to start with legal positivism and argue really that this book, which Hart publishes in the 1920s, has a very, very rich intellectual heritage. And he himself concedes a number of influences, Hobbes, and Austin particularly, he's a jurisprudential thinker, just after Hobbes. And I'll talk a bit about both of those. But it was actually one of the lectures this morning which made me go back and reread the Crito, which is Plato's famous dialogue on the law. And it made me realise that perhaps Socrates is the best person to look to for the first statement of legal positivism, or at least the first person to maybe maintain an argument that there is a difference between what is the law and what is moral. In the course of the Crito, anyone who doesn't know, Socrates is awaiting his death, having been sentenced to death under the Athenian law for corrupting the youth and various other things. And his friend Crito arrives to bust him out. And Socrates, in the course of that dialogue, anthropomorphizes the laws of Athens and explains to Crito what the laws of Athens would say if he were to flee from Athens and save his own life. And what he says is that he says that I've entered into an agreement with the law of Athens. That agreement has delivered to me an education, my personhood, my whole life has been as a result of this agreement. If I were to flee now, I would leave the very laws which has formed me as a human being, as a human subject, open to being undermined. And so what Socrates is explaining to Crito is that it's possible to morally reason about when to reject the law and when to accept it. I think that's a very significant and nuanced moral position that Socrates takes, and it's one which comes to be reflected later on in the theories which will lead to Hart and Hart's work. So Socrates, jumping forward from Socrates to Hobbes, so a small jump. Hobbes is obviously writing after the English Civil War, which he didn't like, I don't think, and at least saw it as an instance of great chaos, and it leads him to formulate his concept of man in the state of nature. The state of nature being a state in which there are no laws, in which human subjects pursue their self-interest with no limitation, and that for Hobbes is a state of war. And it's not very rational to stay in a state of war, because you won't last very long. So Hobbes says that the rational thing to do is to submit yourself to the authority of a monarch. And he goes on to argue that that authority should be absolute, undiluted, etc. So for Hobbes, it's rational for man to want to avoid the state of nature, and so it becomes rational for him to submit himself to laws. But the key distinction that will go on to be developed is that Hobbes is not saying that law gets its authority as a result of its direct connection to morality. So hold Hobbes in opposition to someone like Thomas Aquinas or Cicero, who is detailed in a very effective handout that John Halloway handed out yesterday, who are saying that the reason you follow the law is because the law is morality. For Thomas Aquinas, the law is God. And so to break the law is to be immoral. There is no distinction between the two things. Whereas I think what Socrates and Hobbes, to a lesser extent, illustrate is that the basis of law is no longer morality as such. It's actually self-interest. At least for, perhaps less for Socrates, but certainly for Hobbes. The argument is, in Hobbes, that you enter into this submission beneath the monarch because it's in your rational self-interest to do so. It doesn't have necessarily any necessary connection with morality. Of course, law might reflect morality, it might happen to coincide with morality, but there is no necessary connection between the two. Because the basis of law is an agreement and not morality. So that then goes on to leads to Austin. Austin is writing slightly after Hobbes and develops his argument very straightforwardly. His argument is very straightforward. In fact, I'll probably tell you all you need to know by telling you the title of this theory, which is legal command theory. Laws are commands issued by a monarch to subjects. The reason that they're distinguished from other expressions of desire is that they are issued with the threat of pain and suffering if you breach them. And that's what laws are. They are nothing more or nothing less. They are commands, and they exist in a separate realm to morality. Again, there could be a connection between the two. But what Austin is denying, and what Hobbes has denied previously, and what to some extent Socrates denied, was that there was a necessary connection between the two. There is some, without morality, there can be law. Laws can be immoral, and it can be moral to break laws as well. Okay, so that's Hobbes and Austin, which brings us up to HLA Hart. So Hart is writing in Cambridge in the 1920s. It's a time when he is immersing him. He was a practicing chancery barrister and was quite a radical, and saw that the enormous amounts of money he was earning in the commercial bar didn't really work with his social justice principles. So he goes to work at the University of Cambridge, has a very quickly successful career there, and he becomes very influenced by the philosophy of language, because Cambridge at that time is somewhere where enormous advances in the philosophy of language are taking place. And you can see that in his opening contribution to jurisprudence, when he writes his first major paper. His argument is that, and while you're listening to this argument, it struck me that anyone who's read the McIntyre book may want to compare this argument with what McIntyre says about morality. And we'll come back to talk about whether or not there is a relationship between the developments in jurisprudence and the way we're thinking about this question, and developments in morality as well. Because Hart's argument is that terms like state, right, and particularly for Hart, the subject of his paper is the term corporation, don't behave like other words. They don't have synonyms that are easily applicable. They don't have definitions which are suitably applied in all circumstances. What you need to do, if you're going to have any hope of understanding these terms, is to look at the function they are playing in the context of the sentences in which they arise. And I mean, it's a long time since I've looked at positivism, but that seems to me to be quite a positivist attitude. That words have no meaning in themselves, they play functions, and it has some, Bertrand Russell was writing a similar paper around the same time about the word the, and came to roughly the same conclusion. So anyway, look at words as the function they play, rather than try and imagine that they have a very succinct and easy definition in themselves. What that leads him to, I mean, that in itself is a positivist statement, because he's saying that that the term right is not a moral term, it's a term which is functional, and it's functional in a context. That sort of starting point leads him to develop his major theory of law in the concept of law. The concept of law, he sets out to describe the entirety of the legal system, what is happening when we are submitting ourselves to laws. And the essence for Hart is that there is basically just rules. Our system is similar to command theory, but more nuanced, Hart would say. So Hart says that what we have are two kinds of rules, primary rules and secondary rules. Primary rules are rules which you would think of, everyone else would think of as law, most people think of as law. They're prohibitions, things you have to do, and speed limits, do not kill, etc., do not steal. Secondary laws are laws about primary laws. So they're the laws which decide how you decide which primary laws are going to be enacted. They're laws about how you choose the people who choose the primary laws. He splits the category of secondary laws into subcategories. This is getting very technical and boring, but I will soldier through it. Into subcategories of rules of recognition, which is how you come to recognise a primary rule. Rules of adjudication, which is how you decide how these laws are to be adjudicated in the court. And he says that the foundational rule is the primary rule of recognition. The primary rule of recognition being the one rule to rule them all, if you like. The one rule which decides which is the final word on what primary rules are primary rules. So for us, that's a kind of combination between Parliament, the legislature, and the Supreme Court. That's what Hart would say is our primary rule of recognition. So his point is that laws are rules, and not much else. And that there are lots of different kinds of rules behaving in lots of different ways, but that in essence there is no connection between that and that there is no necessary connection between that and morality. That's not to say that positivists have to argue there is no connection between law and morality. So Hart would say that laws often laws will overlap with morality, and he'll also say that there is this fundamental moral core to all legal systems, and he inherits this, I think, directly from Hobbes. He says that there are certain truisms, he calls them truisms, about the way human beings behave. There are certain truisms about the way we have to exist as human beings, which will imbue our legal system with some degree of morality. So some of these truisms, he says, are our inherent vulnerability to one another. We are inherently vulnerable when we're walking down the street. And I mean, in this sense, I mean, I don't think he treats vulnerability as a particularly loaded term. It simply means I could, if I wanted to, bash you over the head with a rock. And so a system of rules will have to reflect the fact that there are certain things about the way we exist which require limits and regulation. So he goes on, other ones include we are only altruistic in a limited way. So we can only help each other so much. So you might, it will happen that legal systems come to include some regulation to encourage greater altruism. But he says, apart from this essential core of the legal system, which reflects morality, but only reflects morality because we are human beings, and it has to. There is no necessary connection between law and morality. You could have an unjust system of law. I think, thinking about, I think I've got another sort of 5 or 6 minutes, and I want to talk a bit about where we are today, and sort of say that really none of this matters in the broadest possible way. It matters because natural law, I think the development of legal positivism is very valuable, precisely because of what Socrates, but partly captured by what Socrates articulates, was that if you believe in natural law, then breaching the law, breaking the law, is all automatically immoral by definition. It's only with legal positivism that you come to see that there could be a difference between our moral judgment as citizens and what is reflected in our system of rules. And I think that's a very powerful tool, but I think fundamentally that legal positivism is a sham and a lie. And I'll explain why. One, I think, in order to get any handle on what the judiciary are doing today, in today's context, we really have to look at the political position. And when I did this talk previously, there was a question raised about how you reconcile those theories with today. I don't think you can, really, because the judiciary are very confused about their own role today. They're not sure whether they're meant to be legal positivists or trying to enforce some notion of natural law. And you can really see that in the judgments that they deliver, which I can come on to talk about, specifically around the assisted suicide discussion. But what I really want to say first is there are some key trends, I think, defining what the judiciary are up to today. The first of those trends is that we have a very politically weak legislature, in that obviously fewer people are going out to vote for their political parties, the result of a lack of any democratic mandate and a failure to engage the public. The consequence of that is a lack of authority, and that's reflected in the second of the two trends, which is that Parliament is giving itself powers which are easily open to judicial review and judicial intervention. They're giving themselves powers to only make decisions on very qualified bases, giving themselves enormous numbers of hoops to jump through before they can make any decisions. And almost always the decision making involves the appointment of someone to basically make the decision for them. And if they fail to do that in the right way, they can be judicially reviewed and their decision can be quashed. And the third trend, I think, is a public who are more willing to vent their spleen against their elected representatives through courts than through traditional democratic engagement. And I think all three of those trends were captured in a recent case involving a local hospital near where I live, which was the A&E ward in Lewisham was being closed down. The Secretary of State for Health decided that he wanted to close Lewisham Hospital down. Now, he didn't decide that he wanted to close the hospital down, of course. He appointed an administrator to examine the local authority trust in Greenwich. The administrator decided that it would be a good idea to close the A&E in Lewisham. And there was uproar in Lewisham, which is where my parents still live. You had demonstrations on the street, people were sticking up, Save Our NHS in the window, etc., etc. And what they did eventually was judicially review his decision. And because he established this enormous framework for having his decisions made, basically in this context, he had to appoint the administrator first of all. He had to appoint the administrator. He couldn't just decide to close Lewisham down. He had to appoint the administrator. The administrator then had to make recommendations. He then had to make a separate decision as to whether or not to rely on those recommendations. So the judicial review said, well, he couldn't make, because he'd been instructed to look at Greenwich, and he instructed to close down a hospital department in Lewisham, he wasn't entitled to make those recommendations. Plus, because he wasn't entitled to make the recommendations, the minister wasn't entitled to rely on those recommendations. And of course, the court found that both of those things were right. And firstly, that the administrator acted in excess of his own powers, and the Secretary of State acted in excess of his own powers. So the decision was quashed. So one way of discussing, one thing I was trying to do with this instance is understand whether this fits easily into a legal positivist or natural law conception. I just don't think it does. I think the judge can say, all I'm doing is my role, which is interpreting this law, but the law gives him an enormous amount of power to interfere in political decisions. So he's entitled, the judge can say, look, what do you want me to do? If the consequence of this is perceived to be political, then okay. But in reality, the process is just enforcing the law that you've given him. So it is, I mean, in one sense, it's positivist. We can understand the process that the judge went through in a positivist way. All he did was decide what was said, in fact, three words. It came down to the interpretation of three words, which was in relate, what, 4 words? 5 words. It's been a long weekend. In relation to the trust. So the question was whether or not, when he said in the statute, in relation to the trust, did he mean the trust that he'd been appointed to, or could he make recommendations in relation to another trust? And because those words have been used in a narrow context elsewhere in the same statute, the judge said, well, Parliament's intention was to give you a narrow definition of in relation to the trust. Of course, in reality, Parliament never considered that, it never dreamed that it would come up. But, so they quashed the decision. So really, I can come on to talk about assisted suicide if we like, but it struck me that the old debate between legal positivism and natural law is a little bit out of date now. And the only real way of understanding the relationship between us and the judiciary is to really have a look at the political context that the judiciary find themselves in. And I think there are numerous examples, in addition to the Lewisian example, that show that the reason why judges have been given the power to intervene is not just because they're judicially activists. It's not just a case that they are crazy and desperate to be political. They're not. They're being given decisions which have political consequences. And that's a result of a very weak legislature and a parliament which is creating powers for itself which are heavily qualified. So I think that's been around 25 minutes, so I'll leave it there.
Thank you very much, Luke. Questions, comments, contributions?
Laws, at least, sorry.
We'll give Luke a rest, sorry.
Thanks, John.
Okay. Yes, laws, at least in theory, in our democracy, are supposed to originate in Parliament. So if you're examining the nature of laws, whether they're positivist or moral, stroke, natural, should you not perhaps be looking at what the intention was in creating the law in the first place? Or are these experts like Mr. Hart perhaps looking at the application of the laws rather than the laws themselves?
Okay, I'll take a round of questions. I think there's another question at the front.
No, sorry,
Okay.
Yeah, it's on the question of kind of what laws to obey and disobey. At least with the kind of, between the two things that you described earlier, the legal logical positivism, or the legal positivism and the natural law, I can see that there's, you know, some sort of sets of ideas and people having fought over definitions like of those things to try and make the law a bit more wieldy and more useful to the people who need to use it. The thing that you're describing today, and how the law is sort of unwillingly dragged into everything by other people who don't want to take responsibility for what they do. That means the law is, I'd like to respect the law, Socratically or something else, but you know, when you have stupid laws, I don't, like my local Green Council's 20-mile-an-hour speed limits everywhere, the police say they won't bother enforcing because it's stupid. So, you know, those kinds of it doesn't seem worth it. It seems a strange logic. It doesn't seem worth to protest the law if the law doesn't mean anything.
I think you've raised a very interesting question. Perhaps what people should think about as well is it only that the laws that are being passed are stupid, or is there a little bit more that's going on, in addition to the stupid?
Potentially all laws can be stupid if applied badly or done in the wrong way, or you get particular judges. You know.
You see, you spurred everyone to speaking. Over there.
Firstly, it was really interesting to link the birth of the concept of law with the concepts in Cambridge at the time, and especially then you made the link to the McIntyre point. And I think what's really interesting there is that, so the idea at Cambridge at the time was that we could think of something like a spider revolution in philosophy, where we can think about what the spider revolution in philosophy I want to do. We can look at the context of things, and that's a good way of getting a handle on how things work consensus. The way, if I'm just elaborating on your point about McIntyre, what's interesting there is that, so McIntyre talks a lot about the fact that the context in which these things make sense no longer supplied. And so what we have is when Hart says, I'm going to find how the laws are used, he finds them used, but like not in an entirely non-moral context, because the telos, the thing that would make sense of the function of the laws is gone, and so he only has to function in a narrow technical sense. I think that's the point you're making. But I would like you to elaborate on why exactly positivism can't make sense of the current predicament. I get your point, like, it might not be very helpful in the political context, but has positivism ever really aspired to do that? Surely it just wants us to give an account of how the law would function in society.
Okay.
I wonder if you could say something about just the over-regulation of about private knowledge, I suppose. I'm just thinking about the discussion, for example, around rape and what's happened to.
Can you speak up?
I'm just asking a question about the way that the law has intruded more and more into our private sphere, and in a more and more specific way. And for example, around the law around rape, for example, which has been more, defined wider and wider and wider, and child protection as well is another example. And it seems like the absence of morality or a moral sense in society, or the idea amongst the legislature that there is an absence of morality, whether there is or not, but that there's no kind of moral framework to which we all agree, means that the law is being looked to, and then because it isn't, then it's a kind of technical solution. It becomes a technical solution rather than anything wider. And so this whole point, I suppose, that we were discussing earlier in the Smith thing as well, around the lack, that it's not about doing no harm, I suppose. The framework isn't preventing harm in that kind of broad sense, but it is about, comes about how should you behave.
Okay, there's a number of people who joined to speak, but I'll just let Luke come back on some of those questions.
Okay, so this is an interesting line of questioning, because I think the McIntyre point is instructive. I think McIntyre's basically right in his diagnosis of what has happened. We've lost, there's something which is absent in contemporary society, which is, I think, a common way of resolving our moral problems. What replaces it, I think, is, in many circumstances, in some of the circumstances you mentioned, is law. So law begins to grow into more areas of private life, private judgment calls. And I don't really want to talk about it all that much, but rape is a good example. When you have a culture in which the boundaries of polite sexual behaviour are not agreed upon, we're contentious, and we have no way, we seem to lack any way of forming any common understanding of what those boundaries would look like. We become more deferential on the law to do the job for us. And understanding what that process entails is quite tricky. I think part of the trends I've talked about being a legislature more willing to enact the laws which supplant moral thinking, supplant moral behaviour, help. But we have to, there is a dynamic in the third dynamic I spoke about, the absence of, or a public more willing to delegate these decisions to the law, and more willing to allow the law to make them up, to make people's minds up for them. And I think we have seen that as a general trend. I don't know if that's a specific example. But that's also why positivism is alive and sham. Because if you look at the assisted suicide discussion, what I hadn't quite appreciated is how willing some judges are to see themselves as moral guardians of the people and make. I mean, it is quite remarkable. I thought when I did the talk this out, I called it "Are We All Legal Positivists Now?" And I hadn't really gone through the suicide judgment at the time. But there's this paragraph from Lord Mance where he says, "There is force in the point that difficult or unpopular decisions which need to be taken are on some occasions more easily grasped by judges than by the legislature. Although judges are not directly accountable to the electorate, there are occasions when their relative freedom from the pressures of the moment enables them to take a more detached view. As Lord Brown said in the Countryside Alliance case, which relates to fox hunting, sometimes the majority misuses its powers. Not least this may occur when what perceived as moral issues are involved." So I mean, that's legal positivism is a lie, because the system is populated by people, and sometimes judges take their role and use it in particular ways. It's just not neutral in the way that positivism imagines. And of course, the problem is that in the same judgment later on, another judge spends 40 paragraphs explaining why he can't make these kind of moral decisions and they should be left to the legislature. So it's just a complete confusion and chaos at the Supreme Court at the moment, I think. They simply can't decide what their proper role is. So in answer to that question, I mean, positivism is a philosophical movement I haven't looked at for a long time, but at least legal positivism is, I think, is a sham and a lie. I'm just trying to look at what other questions there are. The question about which laws to obey and disobey. It's a very interesting question. I think that's why I kind of brought Socrates in quite late in developing this talk. But I couldn't resist it because it really is, he is making a very sophisticated assertion of his own individual morality in consideration of the morality of Athens. So what he's saying is, look, I've got this code that I have to, I've got this code that I don't agree with. I don't agree that I've corrupted the youth or spread malicious lies about Athens or whatever. But he is saying, now that the judgment has been passed, if I, as an individual, were to leave, I would be harming the very institutions that gave me my personhood, gave me myself. So he is making a judgment about whether or not it's right or wrong to obey and disobey laws. And when it comes to the question in today's context, that's really all you can do. You can make a judgment about whether or not it's okay to break a law or not. And that's why the positivist insight that there is a separation between the two is very valuable. Because as I said in the discussion, if you live in Aquinas' world where you have natural law, you can't assert that. You can't argue it because law is morality, morality is law, and for Aquinas, law is God. And that was the same was true with Aristotle. You know, Aristotle was a natural law theorist who said, you know, the purpose of laws is to create virtuous habits in citizens. And if legislators aren't making laws which encourage virtuous habits in citizens, and therefore move them towards their telos, then the legislature are failing, and they're not making law. They're doing something else. So the point is that natural law tells you, and it makes sense in the context of a very rigid Athenian society, that law is morality. The sanctions that the state can impose on you are really one and the same and reflective of the morality of the community. So the good insight of positivism is that you can reason about whether or not to break the law, and Socrates was doing that in a narrow capacity, but then it grows and expands in the way that I hope I've described.
As Luke said, he gave this talk to the London Legal Salon on Thursday night, and there were quite a few lawyers in the audience. And Luke made what I think he thought was a very uncontroversial point when he said, as he's just said now, more and more we defer to the law. And of course, a number of the lawyers put their hands up and said, well, why is that a problem? Surely that's a good thing. And, you know, I don't think we should, maybe there are some people in this audience who think that. It wouldn't surprise me because that's certainly what a lot of people in society think. So I think it is worth us asking ourselves, is that a problem, and if so, why? But there are a number of people who want to speak. No, your hands come down.
No, that's up. Yes, just a question about can we defend a Lockean take on natural law? So I I take your points about an Aristotelian interpretation of natural laws. So then, if the laws describe virtue, then there's actually no freedom for the citizen to make up their own to determine what virtue is for themselves, because it just is what the law is. Whereas for Locke, the kind of just commonwealth should follow natural law, which says my life and liberty of the state should be protected, both from other citizens, but also from the state. And it's that kind of limited conception of state action which made its way into the American Constitution. So with a similar situation where there's some conception of natural law be beneficial as a more beneficial protection of freedom in this context.
Yep. Jean?
Well, I'm not a lawyer, but I work with a lot of lawyers in the US who see themselves as the guardians of democracy. But the point that I want to make is that I think that the law is a good indicator of what's going on more generally in society. So if you look at the great social movements in the past, let's just look a little way back, say to the 60s and the 70s, there was the sense of the moral, autonomous, active individual. But that person tied their individual interests to that of a broader movement for social good. And you take, for example, the civil rights movements, many, many movements like that. So there was the sense of me, but it was me, the morally autonomous, active political citizen who was looking to the law to change, but to change for the common good, and my self-interest is tied to the top common good. The change that I think has happened is that now we have a sense of me the victim, who is not tying my individual interests, and don't see myself as a political agent, but I see myself as this victim deserving of compensation, not part of anything much broader. And the only outlet for my dissent, if you like, is to use the law. And in that sense, I'm not seen as a morally autonomous individual, because I'm looking to the legal system to defend my interests. And what the law is, you can't blame the law. The law is just a reflection of what's going on in a broader context.
Hi, I was just wondering what you thought about criminal lawyers in particular. So I'm pretty much a natural law theorist, and I think that you can have virtues in law and society and morality with law. But so basically, I view criminal law as the person who gets the best case wins and one of them wrong. But that's bad because that's not getting to truth. That's. Do you understand what I mean? Sorry.
Well, I'm not sure.
Okay, so what I'm trying to get is, you can have a case, and the person who's committed the wrongdoing goes free, and I think that's morally wrong. But the law doesn't really care about that per se. But what I'm asking is, do you think we should care about that?
I think they do.
There are lots more hands. Yeah.
I'm interested in, I don't think it is a case today that it's a misapplication of the law. I'm not speaking from a legal background at all, but this thing of avoiding responsibility and the law being brought in, and I'm just, what that immediately strikes me, I'm just thinking Hannah Arendt, responsibility of judgment here. And I think if ever there was I don't think she says it such, but to me, her example of what happened in Nazi Germany seems to me more like natural law than legal positivism, where morality, where the law actually was immoral, but it was accepted because it was the law, it was moral, and therefore following the law became being a moral person, even though it meant the Holocaust. So that was. And then she locates, so she then says, well, what was that about? What happened to morality there? And so she then makes something a really good, robust case of morality being a case of individual thinking, right? And so it has to be individual, and if it's an individual thing, it can't be a kind of rule-governed thing in the way that I think the law perhaps has to be, or science has to be. So you can't look to these bodies of knowledge that work in a different way to individual moral thinking. So that's why I think perhaps today we argue that the extension of the law into these different realms is actually immoral. And that's not to do with the law intrinsically being immoral, it's more to do with the function. What you were talking about, the linguistic function. The point about the Cambridge linguists was that they also said the meaning is relational. It's not just functional, it's in relation to everything else. So when you've got a shift happening at all levels of society, the meaning of it becomes different. So anyway, so we come back to, well, what could we then do? And then it is up to us to be our own Socrates and decide, well, when do we decide a law is worth obeying, when is it worth breaking? We can only do that ourselves. But there has to be some criteria. And the only thing I can think of, the best thing I can think of, is that goes back to what I think Joe Ruggieri mentioned about having to consider the ergon of things, which is the characteristic of something, and to be true to that. But I think that the characteristic of things isn't always evident, self-evident, it requires work. That's as far as I've got. Anyway.
And to your right?
Yeah. The United States Constitution strikes me as an example of a very good and moral law, in some ways standing above the way it's interpreted. So that the First Amendment, if we had it here, there would be fewer problems. I'm not saying that the First Amendment was always followed very well. There are many examples in early 20th century where it was got rid of, but it stands as an example of a law that you would really want. I think it's a very good exemplary law. And
it tells us what it says.
The First Amendment, sorry, it's freedom of expression is my favorite bit of it. I can't quote it chapter and verse, I'm afraid. But I mean, I think, and freedom of religion as well, freedom of conscience, freedom. So it goes, I like the Second Amendment as well. Freedom of speech, yes, that's the one. So that's a law that stands as a sort of moral example in some ways, that in fact is something that you would actually want to have. And to me, it seems like as good a moral as well as a law as anything else. And I wonder whether you'd talk about that, because it does seem sort of confusing when we are saying that, you know, should we obey the U.S. Constitution or not? A lot of people in the U.S. would say yes. Well, that was just wrong, and they're using the sort of the interpretive latitude that they're given to get rid of the law. And I'm just curious about what you have to say about that.
Can I see who else wants to speak? Okay. We'll go to your right next.
Okay, what I'm interested by, because I agree with you, there's that trend of the outsourcing of authority. What seems interesting as well is that when you have more and more attempts by, particularly by the state, to be overtly moralistic, whether that's around anti-smoking legislation, around drinking control zones, there's a kind of, it's kind of devolved, I suppose. Actually, it's not quite, these are kind of quasi kind of legal functions people have. It's not directly made illegal, but then it's outsourced to various people who previously would have not had that authority to enforce these kind of legal. So it seems to be a strange process that's going on, because there are also things being taken out of the purview of the courts and the law. I mean, another good example is increasing movements to medicalise the treatment of drug users. To no longer say that this is something which is illegal, but to treat it as a medical problem. So it doesn't seem to be straightforwardly across the board that the law has been brought into everything. And there's some things that have been passed out from it, but yeah, that's just my impression.
Yeah, this is probably my lack of understanding about the different definitions that we're using here in terms of natural law and the positive bit. So the positivist law, you say, is a sham but is useful. Is natural law, because it's moral, good or bad? Should law not be moral? Because I would have thought we would say it should be. And is questioning law necessarily contradictory to the law being moral? Because I don't see a distinct, I think the law should, I agree with what Jean's point, I think, that the law should reflect society's sense of what is right and wrong. Well, that doesn't mean you can't question it.
Yeah.
Yeah, I mean, just going back to another question. I'm not quite sure what the exact dispute is between natural law theory and legal positivism, because we might all agree that there is a natural law, if that's your way of saying there are moral fund and notifications. We can also agree that there are laws which have been passed by the state, whether you like it or not, there are these laws. And now the question is, what's the conceptual relationship between the two things? I mean, and you could phrase that question by asking either, is a positive law justified as a positive law only if it reflects natural law, or is it just a different sort of obligation? But the underlying question, I think, is a bit tangential, is this: what should the relationship be between natural law and positive law? And here we have the old debates, like the Hart debates about the demoralization of the law. I mean, the old debates in the early 1960s about homosexuality, pornography, these sorts of things, were about whether things that everybody was supposed to think were wicked should nonetheless be illegal. Now, the usual counterargument to that is a sort of rehash approach to admit is there should be no laws that stop people doing things that don't harm anybody else without their consent, which also sounds really plausible. But then you have cases like incest, consensual incest. Even most liberals balk at that. Do you really want to say that brothers and sisters should not be stopped by law having sex, even though they both consent to that? And then we ask them about the concept of harm. I mean, what exactly is harm? It's not talking on harm. Just wonder what they've got to think about this.
When discussing the relationship or just separately the two categories, law and morality, I think classical thinkers tend to talk about, like Rousseau or Carl Schmitt, tend to talk about the general will, meaning there is an understanding that the society has some kind of common understanding on certain values, priorities, etc. Given that at the present time societies are increasingly becoming more pluralistic and fragmented, where do you see this direction taking its route in the relationship between the two?
Anyone else want to speak? Yeah?
Well, obviously, Jean was onto something by effectively saying we get the law we deserve, but Luke identified the real problem, which is that most of us aren't participating in the process. You know, the majority of people who are politically engaged are a minority of society, and that's where the big gap lies. I think where Jean goes too far, however, is that this is a dialectical process. So, you know, it's very rare for the victim of anything to call themselves the victim of something. It's extremely rare for so-called vulnerable groups to self-identify as vulnerable groups. Rather, these labels are attributed to them by moral entrepreneurs, typically lawyers, and that's where, you know, the process has now gone full circle. It is lawyers who are saying, you're the victim, you know, and this is what needs to happen.
Anyone else want to ask a question, comment? I'll bring Luke in a moment. I just want to say a few words myself, because it seems to me that legal positivism is being very much a theory that's being developed on the back of practice. In other words, what's happened in Britain over the last few centuries is that legal positivism has been the dominant theory, but only because that is the way law has been practiced in this country, by which I mean that law has had a very narrow, confined remit for itself. And it's been able to do that in a society where all political issues were hived off to Parliament. And you can do that in a society where you don't have fundamental disagreements over in what direction the law should go. So it's almost like, I know Frank this morning was talking about how Adam Smith kept referring to this independent arbitrator, the sort of benign legislator who could, you know, just ensure that society stayed on the straight and narrow. Well, you can do that so long as society is basically going in the right direction, because your lawyers, your judiciary can just sort of ensure that when they take one step off the road, they get put back onto the road again. So that's very much how it worked in Britain for a few hundred years. But at certain times, that simply isn't an adequate way of understanding the law for the reasons that people have given, namely that there does need to be some morality and there does need to be some politics behind the underpinnings of the law. And you can see that with people like John Locke, who use that sort of politicised, if you like, notion of rights as a means of actually taking society forward, for hence you get the First Amendment of the American Constitution. So that's where a natural rights approach is used very much in a positive, beneficial way. and that's sort of 16th, 17th century, a bit of 18th century, but then it, certainly in Britain, it never really got a hold in Britain. Except after the Second World War, which was undoubtedly a reaction to the horrors of the Second World War. And the idea came about then with the Universal Declaration of Human Rights and also the European Convention of Human Rights, that there needed to be some document that enshrined rights that could limit the powers of the state. And so that's why you get a very different politicized document, which is ostensibly enshrining rights, but they're a very different kind of rights from the rights that you get in the First Amendment of the American Constitution. But that never really took off. I mean, the European Convention on Human Rights, although it was entered into, what, in about 1948, most people never talked about it for decades. It's only become a central feature of political life in the last 10 or so years. And the reason for that, it seems to me, is because we have lost any sense of being able to deal with problems in a political way. So we are tending to shunt them off to the judiciary. Now, Luke is quite right to draw attention to the way in which someone like Lord Mance on the assisted suicide judgment will say that there are certain issues which it is better for us as a judiciary to deal with. And they do deal with them because they have to deal with them. But the point is, and this is what I think is really troubling, is that they deal with all these questions, these fundamentally moral and political questions, in an amoral and an apolitical way. They seem to think you can resolve the question of assisted suicide by looking at precedent. In other words, what have other judges, often judges in Strasbourg, said about this issue before? And the actual consideration of the real political and moral issues behind all of these issues just doesn't get dealt with. And that's why, I won't explain why, but I think fundamentally we've now got the worst of both approaches. We've got the worst aspects of a natural law theory, married to the worst aspects of a legal positivism approach. And that's why we've got the mess that we've got now, which is thoroughly bad both for politics, as it happens, and for law. So, sorry, that was my tuppence worth. Now I've got that off my chest, I feel much better. Luke, there are plenty of other questions to be dealt with.
Yeah, I'll try not to as many as I can. I've got about 2 minutes. So that gives me a convenient excuse not to answer most of them. Very helpful. I think I was interested in your comment about Arendt, because I think our understanding is that the reason why I understand that Eichmann in Jerusalem is so controversial is that she was saying what you have is a faith, is a thoughtlessness. You are following blindly the law that you've been given. So really, what Arendt is accusing Eichmann of failing to do is make a Socratic judgment of the kind that he made. You know, he's failing to engage his own inner moral self to consider whether or not he should be doing what he's doing under the legal system that he's got. The reason why natural law is so problematic, I mean, the point is that natural law is only defined as natural law once legal positivism comes along. So it's defined as an overarching term simply so that positivists can say what they are not. So actually it's a very difficult term, but I think the key argument, the key point, and hopefully this stresses something around the question of should the law not be moral. I think the key insight of positivism was that the law and morality aren't the same thing, basically, that there's no necessary connection between the two. So to that extent it is useful, but we know that in today's context, for the reason we talked about, it's a lie, because judges do all the things that John was talking about. But anyway, so I think really, if in Nazi, I mean, there is a whole debate about whether or not the Nazis had law. Right? Some people think they did, some people think they didn't. But to my mind, it seems that they did have law. So yes, positivist. But those involved in it failed to judge themselves in relation to that law, and that was the failure that Arendt talks about. She also is an excellent commentator on how the law comes to try and cope with social issues in her essays on Little Rock, which is a great other part of that book. Kevin, I don't know, I'll have to test myself on the Constitution again, but I'm not sure that we, citizens, obey the Constitution. The Constitution limits the actions of the state, and it's actually what really distinguishes it from the European Convention. Because the European Convention says you can have these freedoms if the state if it's necessary, but the state can qualify them if it's necessary and proportionate to do so. And who gets to decide whether it's necessary or proportionate to do so? The judges do. So basically, whereas in the Constitution you have a document which says you shan't make laws that affect free speech, you shan't take people's guns, blah blah blah. The European Convention says we will take your freedom, but only if these circumstances pertain or something. So that's the real difference between those two documents. And of course, in the States, you have another debate emerging about whether or not the Constitution should be read in the terms at the time when it was drafted. So judges like Scalia in the States who argue we can only consider what the Constitution is meant to do in the context of when it was written. And other people who are more in favour of interpreting the Constitution to solve certain social and political issues. So other justices on the bench think that it can be used to justify all sorts of things, which Scalia at least would say, no, it has to be read in the terms that it was written. So there is that dynamic in the States as well, even in relation to the Constitution. Even though in and of itself it's a wonderful symbolic document because it's a declaration that the state will not do certain things. I think the legal reality in the States is that it does get used to do things which are undemocratic. I think that certain arguments are made in the Supreme Court which do encourage the justices to be activists, but I can't really get into that at the moment. So sort of final concluding remarks really, and answering the question, should the law be moral? I think in an ideal society the law would reflect the community's morality as far as possible. But today I think it's unhelpful to look at the law in moral terms. I think we need to look at the function that law is playing, the impact it's having on our moral and political life. And for that reason, to ask whether or not, to argue we should be making the law more moral is deeply problematic. And at least in that much, the insights of legal positivism can be helpful.